Okay, Chapter 4. Chapter 4, we're going to recover basically from what you've learned from your EMT course, ethical, medical, and legal considerations in advanced EMT practice. So a lot of this will be review, but it is really good information. I mean, this is information that's critical for everyday patient interaction. So we often downplay it, but in reality, it's something we really ought to pay more attention to. Again, this is viewing this lecture is no substitute for actually reading and studying from the textbook. All right, so the standard that we see again here for this chapter is the AEMT applies fundamental knowledge of the EMS system, safety, well-being of the AEMT, medical, legal, and ethical issues into the provision of emergency care. Your objectives, of course, are listed in the beginning of the chapter on pages 58, 59, and 60. There are 21 of those for this chapter. Well, obviously, it carries a little bit of weight because it has a considerable number of objectives. So there are legal and ethical aspects on every EMS call. If we make contact with a patient, we most commonly think of this because we have to get consent. But consent is not the end-all be-all of it. Consent is an important part of it, but there's a lot of ways along the way that legal gets pulled into this, such as driving to the scene, such as are you legally allowed to practice as an EMS provider? Is your service legally authorized to operate as an EMS service? Do you have a physician medical director who grants you the authority to purchase your supply? Because you can't do that without a prescription. So there's a lot of legal aspects of it. Ethically, you have to take into consideration lots of things, like what is the best thing for most people involved. So I'll bring up an example. If you are responding to a cardiac arrest, actually you picked up a cardiac arrest, and you're transporting that cardiac arrest into the hospital, most people would say you transport that person with lights and sirens on. Okay, I'll buy that most people would say that. The other side of that coin is your patient not already dead? I mean, the likelihood of survival we know is fairly slim. And in many cases, what they do in the hospital, particularly if you have a paramedic assist with you, isn't much more than what the paramedic does. So is it ethically appropriate to put everybody else's lives in danger to drive lights and sirens to the hospital for somebody who we know has most likely is going to end up permanently dead? I think that's a good thought to chew on for a little while, simply for the fact that many people probably don't consider that. So at times, application of what seems to be an unambiguous law and ethical principle can be difficult to resolve. Sometimes we get stuck in the middle. So if it may say, we'll say DNR. DNR could be a good situation, which we have a form that maybe says don't do anything, or we don't have a form that says you have to have a form to withhold resuscitation. Yet we show up, the family is pleading with us to do nothing. They say he has terminal disease, and they just want him to go peacefully. That muckies the waters a bit. And you must have working understanding of laws that apply to emergency medical care and the principles of medical ethics. So what are ethics? Well, the definition of ethics you can find on page 60 in your textbook. It is the branch of philosophy that tries to answer the questions about notions of what is good and bad and what is right and wrong. And in some cases, there is a gray area in a lot of these things. when we talk about ethics and morals. And ethics tends to be from a broader perspective, and morals tend to be from a personal perspective. So when we talk about ethics, we have an EMT oath and an EMT code of conduct, which could be considered codes of ethics, basically. And with those, it kind of guides us to what is considered appropriate for our profession. Sometimes our personal morals may get in the way. So you may have an issue with patients that are, I don't know, we'll take homosexual, for example. You may take exception to that. So morally, you may feel that that is wrong, and that may taint your view. Sadly, it happens. But you can't let that happen when you're in the line of duty, because the ethics of the profession need to be your guiding principles. You may not like what you see. None of us like going on a child abuse call, but we don't really have a lot of say in the matter. I think there's some other interesting healthcare moral ethical dilemmas that have come up recently when we talk about, say, the new Affordable Care Act and the requirement for birth control and contraception, and how many of the religious institutions, we'll say the Catholic Church, for example, which is involved with many hospitals, and how they have taken exception to this requirement for family planning. So it continues to raise bigger and bigger questions. So some ethical principles that come up when we start talking about ethics. So, and you can see kind of the short Cliff Notes version in your text. Beneficence is doing good. So, I mean, that's kind of a no-brainer. It's more or less golden rule. I mean, you do unto others as you want done unto yourself. And then non-malfeasance is to do no harm, or basically the medical principle of primum non nocere, which is Latin for first do no harm. So justice, of course, justice is doing what's right in a legal perspective. There is concern for the well-being of others, respect for others, advocacy for others, the patient's rights of self-determination, so whether or not they actually are seen and treated, proper medical route or course for that person. Additionally, we look at things such as objectivity. Can we truly be objective and non-judgmental in many cases of when something maybe doesn't meet our social mores or our social morals or ethics. So avoiding conflicts of interest. So conflict of interest, a good example of that would be if you only would use a certain type of device or a certain medication that may be in your other job or in your professional life sold. You in a way, shape, or form benefited by using only medication A versus medication B, which is from the competitor. And with that, full disclosure to your patients as well. So letting them have a educated look at what the potential benefits and risks are. Due diligence or duty of care. Your due diligence is giving them the full investigation, more or less, the full review prior to making different decisions based off of the patient's needs. Confidentiality, of course, we keep everything we see quiet except for those people who really must know it. And then, of course, adhering to your professional responsibilities, which we covered in Chapter 2. So all of those different responsibilities that you have. So AEMTs should strive to do good and not harm others, and follow the golden rule: do unto others as you would have them do unto you. As simple as that is, and as long as we have heard that in our lives, when we were little kids, we probably heard that. It still holds true. I mean, it's just really that. It's really that simple. So think about it. This goes back to your case study that's in the textbook on 59. I'll let you guys answer those. Laws. So branches of government laws and how they pertain to AEMT practice. Well, we have three general bodies that are responsible for making laws. So the federal government, the state government, and the local government. The federal government sets typically the broadest laws. So the most wide open laws, the least restrictive laws, are typically federal. And then as they funnel down through the state level and then through the local level, who are in most cases bound to uphold those laws, they may restrict them even further. So say, for example, if the federal government says, well, the federal drinking age is 21, it is possible that a state government could say, well, in our state it's 25. So it didn't get less, it didn't become less restrictive, it became more restrictive. And it's possible that a local government would say, well, you can't even drink in our town. No one drinks in our town. So that's possible. Federal, obviously, most of these laws are created by Congress or the legislative branch. Most governments have, at least the state and federal level, have the three-branch system. And so that would include the legislative, the executive, and the judicial. Legislative branch, in our brief review of civics, the legislative branch writes the laws, they create the laws, they introduce the bills, they vote on them, and work to get them signed and passed into law. The executive branch then executes the law, which may or may not require the executive, be it either the governor of the state or the president or the mayor of a city for that matter, to sign off on them in a way of approving it or vetoing it. And then the judicial branch has several different levels of courts that make rulings and decisions related to laws. They not only deal with criminal law, but they also deal with civil and tort law, which are topics we're going to get to here in just a moment. So some things as examples of legislation that we've had comes down from various levels. EMTALA, the Emergency Medical Treatment and Active Labor Act, HIPAA, which is the Health Insurance Portability and Accountability Act, Ryan White Care Act, the new Affordable Care Act. Those sorts of things have come down from the federal government. EMTALA basically says you cannot transfer a patient from one hospital to another without there being appropriate contact made between nurses and providers. Or when I say providers, I generally mean physicians. So you cannot just ditch somebody off on another hospital. That used to happen a lot. There used to be a lot of dumping, that one hospital would call up an ambulance, say, hey, come pick up this patient, take him over to this other hospital. The ambulance shows up on the door, and they're like, hey, we're told to bring this patient here. And the receiving hospital's like, what? We have no idea what you're talking about. We don't even have a room for him. We don't have a bed for him. That used to happen. It would still probably be happening fairly widespread now if it wasn't for this sort of law. So civil versus tort versus criminal law. Civil law pertains basically to vital things, vital statistics, court, family court items such as marriage, divorce, children custody, that sort of thing, as well as some other, look at things like small claims and whatnot. We can also have a second area of civil law called tort law, and tort law has to do with things such as it would be more like the small claims or the slander, libel, negligence, those sorts of things that are more of a quote-unquote crime. No, I don't even want to use that term. An offense, we'll call it, an offense against another person. Whereas then criminal law, of course, has to do with anybody who has broken laws, homicide, reckless driving, assaults and batteries, those sorts of things are prosecuted then under criminal law. And there are certainly cases in which multiple areas of the law are involved. So you could be driving your ambulance, crash your ambulance, kill somebody. You're probably going to be cited and given a criminal trial, and then that family can then turn around and sue you in civil court for damages and loss. So you can be under the gun in multiple perspectives. So authorization to practice. Licensure is granted, or licensure is a granting of official permission by a governmental agency to practice in a regulated occupation or profession. Eligibility for licensure is based on certification or registration. So in Iowa, they still refer to you as having a certification, while technically the process that you undergo to get your Iowa certificate, your Iowa certification, is technically a licensure process. In Nebraska, we refer to it as a license, not a certificate. So now it means in semantics, it doesn't mean the same, but the process is technically the same. So how does this whole process work? Well, you finish class, you are going to be given a certificate of completion. And your certificate of completion says you've finished this course and you are eligible to take the licensing exam or the credentialing exam. So you will then sign up and take the National Registry. The National Registry is the licensing exam or the credentialing exam used by both Iowa and Nebraska to rank you, or I shouldn't say rank you, put you on a list of eligible folks or a registry of eligible folks who are potentially licensable. Once you've passed the National Registry, you're on the list, you have your card or your certificate really from the National Registry, you may then be granted or have to apply for, depending on the state, a state license / certificate. So which gives you then the legal authority under the appropriate conditions to operate. So then you are licensed. And then finally, before you actually get to do anything, you should be undergoing, and each service should have this, and I know that many don't, you should be undergoing a local credentialing process. And the local credentialing process then includes usually writing with a field preceptor or a field training officer to ensure that you are in fact competent to do this job. And perhaps officially or unofficially, this is also the way that your physician medical director approves or disapproves you. So this field training process, maybe you have to go on 10, 15, 20 calls, or maybe there's not a definitive end. It's just kind of when you meet the competencies. It's really your medical director saying, okay, you may use my license. If your service does not have some sort of a program like this, They really should. It will come back to haunt them someday. So EMS personnel must be licensed and authorized by their EMS system medical director to practice. And so as I just mentioned, your field preceptoring program, your FTO process, all of those could potentially fit into that authorization to practice. Your scope of practice legally defines what you are allowed to do in the course of your duties. There is a document in the course page that outlines the scope of practice for the various EMS providers. So I'd recommend that you take a look at that. I'll probably actually move it into week 3 so you can easily find that. The scope of practice is the ceiling. It's the ceiling. It says this is what you can do if you're given the abilities and the authority to do so. Your physician medical director may not extend your scope of practice. Your physician medical director cannot say, well, I know you're an AEMT, but I really want you doing field appendectomies and cutting people's appendix out in the field and then leaving them home. Can't do that. It's illegal. So with that being the scope of practice, that's the cap. Now, your physician medical director can say, I do not want you using a tourniquet. It's your physician medical director's right to do that because he or she has to approve it. So they could say, I only want you doing direct pressure and splinting. I don't want you doing tourniquets. They can do that. They can limit your scope. They cannot expand it. So a physician medical director is the one that ultimately is responsible for the patient care that you provide. So they are going to be held liable if you do something wrong. The scope of practice is something that hasn't always been a nice document to get your hands on and look at. Most states now have published this document. I can also put Nebraska's on there as well for those of you guys that might be interested in a little state-by-state comparison. So, each state and each EMS service has a medical director. Sometimes they're in limbo. I know most recently Iowa was kind of in a transition process from one medical director and was looking for a new one. The state of Nebraska, I work with our physician medical director on a fairly regular basis to discuss numerous issues. And then EMS medical directors are licensed physicians, preferably with a background in emergency medicine and EMS. Now, as soon as I say that, emergency medicine is obviously an interesting field to be in. It's an interesting specialty for physicians. And very, very recently, they have added a subspecialty that physicians can become board certified in, and that's being an EMS physician, or basically overseeing EMS services. So it's not that there's not a lot of emergency medical services board certified physicians out there yet. There are emergency services or emergency medicine physicians. Yes, there certainly are a few of those, but honestly, most of them in the small towns aren't EMS or not emergency medicine board certified. Most of them are family practice docs or general practitioners, so they don't always have that background in EMS and emergency. They kind of do it because they have to. Ultimately, they would all be emergency medical services board certified. But physician medical directors are responsible for your quality assurance and improvement. They have to review your work. That both Nebraska and Iowa require that the physician medical director and or their surrogate review a certain amount of your calls. They may be responsible for continuing education. If you maintain a national registry certification, you will have to be signed off by a physician medical director saying that you're competent. They can be involved in writing your protocols. You may use a system protocol, in which maybe they're on a board that writes these. You may use a statewide protocol, in which your physician medical directors have at least had an opportunity to share their comments in the construction of these. And then the management of inappropriate medical conduct by service EMS providers. when somebody gets in trouble for something they did on a call, that physician medical director really needs to be involved with those discussions, because if a EMS provider gets in trouble and gets in trouble at the state level, it's very possible that the physician's license could also be in jeopardy because of things that EMT did. So this is not something that we need to be going alone on. We need to be dragging the medical director in with us. So what is medical direction? Medical direction is a oversight system from a physician that is responsible for all of the patient care aspects of our service and our providers. All right, so think about a question here. A major hurricane has struck communities across the county line. That must be a heck of a hurricane if it's hitting us here in Iowa. And you volunteer to join a mutual aid disaster team. Which protocols are you to operate under in the other county? So let's say we'll take, for example, Pottawatomie County, which is where Council Bluffs is, and Harrison County, which is the next county north of Pottawatomie County. So Missouri Valley, Iowa is in Harrison. Let's say you're on this disaster team that responds across the county line. Who do you operate under? You operate under the medical direction, the protocols, and the systems of whatever agency you are currently working for. So if you have mutual aid agreements to cross county line, maybe because you're, we'll take for example, well, Crescent, Iowa. Crescent, Iowa, and using the same theme of Harrison and Pottawatomie counties, Crescent's not too terribly far from the Harrison County border. So I suppose it's possible, I don't know this for sure, that Crescent probably ventures into Harrison County from time to time. Well, if it is their response district, that's obviously, that should be a no-brainer. Their physician medical director still is the one that makes the shots there. If, say, they had to go and be in dual response with Missouri Valley, who may have a different medical director. Missouri Valley usually transports to their local hospital. Crescent usually transports to Council Bluffs hospitals. So they may have a different medical director. If they're up there having to respond with them in a emergent situation, in most cases they still will respond under their own protocols. But if there was in a completely different organization, like they're insinuating with this think about it question, that organization probably has yet a different set of protocols. So it's the organization that you're responding with is generally who you operate under. So consent and refusal of care. All patient care requires consent. A lot of times it's taken for granted because we simply show up, we say, hey, how's it going? Hey, can we check you out? Sure. And that's really where a lot of it ends. Remember that at any time during the patient encounter, that patient can decide to change their mind. They may not want you to care for them anymore. They may not want you to do a certain procedure, and that's their right, provided that they fall within the confines of being an informed consent from a competent adult before providing patient care. Sometimes we do this in the form of saying, okay, well, can we check you out? What's going on? Okay, I'd like to put some oxygen on you, or I'd like to start an IV. I'd like to give you this medication. And by talking with our patients, that's how we continue to reinforce that consent. If we walk up to them and say, hey, I'd like to check you out. Okay. And then you start doing things like sticking needles in them and sticking airways in them. And of course, if they're getting an airway, they're probably not quite as conscious as we would think, but we're giving them a medication, poking their finger to get a blood glucose. We start doing those things. Was that really covered under what we told them? We said, I'd like to check you out. Well, you said you'd like to check me out. Basically could be construed to say you wanted to do an exam or an assessment on me. You didn't ask me if it was okay to put all these needles in me. So in theory, you potentially are opening yourselves up. But if you're kind of talking with your patient saying, I'd like to go ahead and do this, I think maybe it will help your blood pressure, or maybe it will help us lower your heart rate a little bit. That helps you stay within those confines of the consent they're giving you, because they have the opportunity to say no. A competent adult patient has the right to refuse all emergency care. So what is competence? How do you determine competence? A lot of it is probably going to have to do with localized protocols, but in general, a patient who is alert, oriented, answering all their questions appropriately, they're of legal age, which in Iowa is 18 and Nebraska is 19. They don't have any other odd extenuating circumstance like they become a emancipated minor, which is the court declaring them legally an adult. That helps us to determine competency. You may have somebody who's been under the influence of something. They're not making appropriate decisions, so they're not competent. Maybe they are developmentally disabled, so may have a disability. They may be a former head injury, something along those lines, and they're not able to make appropriate decisions. Maybe they are just plain crazy, and they're asking you if you can see the purple elephants flying through the room. That tends to lead you down that path of, well, I don't think they're probably completely competent. If necessary and the patient refuses to go and it really truly is a situation in which this person needs care, involve law enforcement. They can invoke emergency protective custody and require this patient to go in. Medical direction, another one. So the more people you get involved in this decision-making process, the better, because the more people that agree with you, there's more backup in case this would ever become a legal issue. Not to mention multiple minds can possibly see different angles on this. And then always act in the patient's best interest. Sometimes regardless of what we beg and plead, we still don't get the patient to agree to go. And that happens. And then document all relative information. Really documenting a refusal of care really almost ought to be a bigger job than documenting one that we transported. There are services that do their darndest to get every patient to sign off and get out of going. In reality, in many cases, it would have been faster to transport them and write that report and be done than it is to get them to sign off, get a hold of certain people here and there, and then to write the report correctly. But many people just scribble a couple lines on there, say, yep, patient didn't want to go, blah, blah, we're done. And eventually, that catches up to people. Only a court can determine legal competence, but medical personnel can determine the patient's or the person's decision-making capacity in an emergency. We have to take into account those things such as mental illness, behavioral or medical emergency. Maybe we have a diabetic who is not responding appropriately. And they're telling you, get away, get away, get away. I've had to almost do an off-the-top rope elbow drop into somebody to try to get them to allow me to treat them because their blood sugar is low. I've had them pretty stinking aggravated. So intoxication, of course, trauma. Maybe they've suffered a head trauma. Maybe they are in shock. And those sorts of things can alter their decision-making abilities. So we need to have at least something, and I don't like how they list this as a sample checklist because it's really not. But we need to make sure we have a signature, and preferably a neutral or a witness actually on the other side. If you can get multiple witnesses, great. So I, the undersigned, have been advised that medical assistance on my behalf is necessary and that refusal of said assistance and transportation may result in death or imperil my health. Nevertheless, I refuse to accept treatment or transport and assume all risks and consequences of my decision and release Gold Cross Ambulance and its employees from any liability arising from my refusal. the patient signs, the witness signs. If you can get one of their family members or friends, maybe somebody that's even tried to encourage them to go, to sign off, or a law enforcement officer, get them to sign off, and then date it, of course. You'll get people who will refuse to sign this even, and then it becomes even a bigger documentation issue. So this all in and of itself is not enough to protect your butt. You need to go through and document the crap out of the assessment you did and all the encouragement that you did to try to get this person to go. It's always safer to transport them in a legal sense when it comes to if something bad would happen to the patient themselves. Now, of course, there's then that other angle you could take on it, that is, well, we could get in a car crash. Well, that's true. You could wreck the ambulance on the way, and that would kind of suck. But for the most part, it's usually safest to just transport the patient. So, to talk about a couple different concepts of consent. Well, first of all, we have expressed. There's also informed. What do we do if the patient refuses to consent to treatment but allows us to assess and transport? And then what is implied consent? So we have a number of those. Number one, expressed consent. When the patient is expressing consent, they are directly telling us, yes, I would like to go. Okay, so they are giving us a verbal verification, a verbal approval that this should happen. All consents, particularly express consents, need to be informed consents. And informed consent means that you educated the person to the benefits and risks of what's going on. So you may say, I would like to go ahead and give you this medication. I think this is what it's going to do, and in most cases it'll be fine, but there's the potential for there to be this, that, and the other side effect. Is that okay? Sure, yes. What do you do if they refuse? Document, document, document. You just got to hang all kinds of paper on that because you are trying to follow your protocol. You're trying to follow the standard of care, and the patient refuses. You also, document the heck out of that, the person was given this, that, and the other information, and still refused. And then implied consent. The concept of implied consent means that there's not somebody who can actually consent. But in the reasonable person theory, if you were a reasonable person and you were able to say yes, would you say yes? So it kind of becomes a judgment call from everybody involved saying, did this person or would this person want to be treated if they could? Do we have a person that's confused? Do we have a minor? There's no parent around. We can't find anybody that can say yes to this. Do we have an unresponsive person? A cardiac arrest? And most people would say, yes, I want to be treated. To bring back that concept of minor consent, patients under 18 not legally permitted, or 19 in Nebraska, permitted to consent to or refuse medical treatment. So parents or guardians have to give permission for medical treatment, and we can treat under the assumption of implied consent if a parent or guardian cannot be reached. So let's say we respond out to a vehicle crash, and it's a lame vehicle crash. At least that's the way I would look at it, is lame. There's really nobody hurt, maybe nicks and cuts and bruises, but honestly, nobody that needs an emergency room. And we can't get a hold of the patient's parents. They're 16 years old. We can't get a hold of their parents. What do we have to do? We have to try to find somebody that will give us the yay or nay. The guardian, an aunt, an uncle, a grandparent, somebody willing to shoulder the responsibility for this. If we show up and this patient is unconscious and not breathing, absolutely, that becomes an implied consent thing. We're not even going to dink around trying to find patients' parents. We're going to get to work on this patient, treat and transport them. Once they are stabilized, then we'll before we go any further, want to get consent. And it might be something that we palm that off onto law enforcement, say, hey, here's the patient's wallet, get a hold of somebody, get them up to the hospital immediately. So that's kind of the minor consent thing. But if it's a minor deal, I shouldn't use minor, it's a very non-emergent situation, we have to get consent from a parent or a guardian. Don't just assume, don't just pick them up and transport them. You have to have consent somewhere in there. If there's no other way of getting consent for those minors, you go ahead and transport them under implied, and then we'll worry about how do we get this taken care of once we get them to the hospital. So legal consequences of failing to obtain proper consent. We may be talking abandonment, assault, battery, or false imprisonment. None of these sound like a particularly great situation to find ourselves in. So claims of abandonment. If we didn't get proper consent or the patient didn't properly refuse, then we can terminate that patient-provider relationship in an inappropriate setting, and there could be a claim of abandonment. Now, most of the time when we talk about abandonment, which in many cases is considered the most critical common offense that an EMS provider could do, is, let's say, for example, we show up at the hospital, the patient's serious condition, we take them into the emergency room, throw them off our cot into the bed, the emergency room bed, and we give a report to this person, and we hustle on out of there, and away we go. Come to find out that was a nursing assistant that was taking a report from us, and that nursing assistant has a scope of practice that does not include everything that an EMT can do. So in those cases, this patient could be considered abandoned. Now, that being said, a lot of it also depends on what the patient requires at the time. So if you simply are taking a patient to the emergency room, they fell down, they hurt their ankle, you didn't start an IV, you didn't give them any medications, you splinted it up and took them in most cases, turning this patient over to an LPN or even an EMT would be appropriate. If we put in an advanced airway and we gave them a number of medications and started an IV, it's going to have to be at least an RN or an AEMT or a paramedic or a physician. So you got to keep that in mind. Depends on what those patients' immediate needs are. We may also have assault. Assault is the threat. Battery is the carrying it out. So when you threaten somebody, you are technically committing assault. So if you would tell somebody, "I'm going to whip your butt," that's assault, provided that they took it seriously and were in fear. And then when you actually take them outside and whip their butt, you have just battered them. So the assault is a threat, battery is carrying it out and doing the physical harm, or even touching them without their approval is battery. So, and then false imprisonment. False imprisonment is transporting somebody when they cannot or when they do not give consent, and we do not have a valid reason to transport them otherwise. So, we have gotten law enforcement involved, medical control involved, and have deemed that this patient definitely needs treatment and transport, and this probably needs to be in protective custody. There's going to be a whole line of paperwork for that. But if the patient's alert, they're oriented, they're able to make appropriate consent, they're of the proper age, and everything falls in line, and you transport them against their will, it's false imprisonment. All right, so you've responded to a very large gathering and note a variety of alcohol products, directed to a huddle in the center where you find a male in his mid-20s, and he has a beer pressed to his forehead. Wow, that's great. So he says he doesn't need any help. His speech is somewhat slurred. He has a smell of alcohol on his breath. Someone in the crowd tells you he hit his head hard on the tailgate of his SUV. So what do you think about this? A couple of things. Number one, he's most likely under the influence of a mind-altering substance. Whether or not he's truly intoxicated or not, remains to be seen. So he has a mind-altering substance. He obviously is injured and is probably not making good choices, so we're considering that, that he's in danger there. And two, he's hit his head hard on the tailgate of his SUV. There's the possibility that he has a head trauma that is also making him not think clearly about this whole thing. So transporting him would be risky without his consent. So it may become a situation that we involve medical control and law enforcement. And number one, the easiest thing to do is get somebody to convince him he needs to go. That's the safest thing to do, get him to say yes. But secondly, then, if we have to go other routes to get him transported, leaving him here alone, or even with some of these other people around, if he truly has a medical or traumatic condition, could be considered abandonment. If we touch him, it could be considered, without his approval, could be considered battery. We pick him up and transport him away, could be considered false imprisonment. So we're hitting all kinds of legal issues here. Shifting gears to death. Resuscitation decisions and recognizing death. 20 years ago, we didn't even talk about this because EMS was all about saving lives, and we don't. I'm going to be honest with you. We rarely save lives. I can probably count on both hands and both feet the number of people's lives I truly actually have saved in over 2 decades of doing this job. Most people, we make a difference. We are there for them in a time of need, but we really honestly didn't save their life. So resuscitation on patients in cardiac arrest, that was what we were taught, and that's what most of us think is, hey, you know, somebody's heart stopped, that's what we're going to do. We're going to get in there, we're going to do the job. There are some times in which we shouldn't do this, okay, where death is obvious. So they have an injury that's incompatible with life, so their head is removed from their body. You can't fix that. There's no super gluing that back on. That's not an injury you can bounce back from. When the patient has an advanced directive of some sort, so such as they have a DNR and it's legal and it's signed, hopefully it's on the right forms and all that. We have a protocol that allows us to observe this and you know, and so on and so on. So they may have a durable power of attorney that's asking you, to defer treatment options to their surrogate. So the patients may have a directive saying legally you can allowed to recognize according to protocol. If you can use a power of attorney, you can use a living will. Most places it's still a DNR or a POLST form. POLST is a physician's order for life-sustaining treatment. In many places that's really catching on. It's the POLST. So, advanced medical directive, living will, healthcare proxy. An advanced medical directive is a generalized term that discusses different written statements regarding a patient's end of life. A living will is a document written by an individual, usually by an attorney, that dictates what sort of medical care he or she does not want or does want. Now, we don't take orders from attorneys. We take orders from physicians. So in many cases, EMS services do not honor living wills. They cannot honor living wills if they don't have a protocol to do so. So it is recommended that patients discuss these things with their physician, and maybe the physician also signs. That helps clarify things for us. In most cases, living wills are intended for long-term things, as opposed to acute or immediate things. So if I go into cardiac arrest right now, usually that's not covered in living wills. It's if I would have to be on a ventilator for months on end, beyond a week, beyond a day, whatever. That's usually where you see living wills. Healthcare proxy and durable power of attorney. These are documents that are granting another person authority to make healthcare decisions for them. So maybe as a person has early onset Alzheimer's, they decide I'm going to make one of my kids my proxy or my durable power of attorney to make those decisions for me. So a do not resuscitate order. You can see this actually better on page 68 in your textbook. That's a sample from one place. The state of Iowa has a specific DNR form, and that will be also posted in your course page for this week. And it allows you to kind of see what they do and do not want. DNRs or DNARs, not attempt resuscitation, must be signed and dated by a physician, and the physician needs to document what they do and do not want the patient to have done, or what the patient does and does not want done. And generally, there is an expiration on them. In many places, if it's not re-signed every year, it goes invalid. So based off of your protocols in your local system, you need to know what is acceptable in our community. Some communities have taken up the charge and said, we will have one form that gets used in our community, period. And that's great. In most cases, we legally will recognize DNRs. Okay, so we have some early signs of death and we have some late signs of death. The late signs of death are a little bit more concrete, while these early signs of death, or what they refer to as presumptive signs of death, are suggestive. So things like absence of pulse and breathing, unresponsiveness to all stimuli, no eyeball movement or pupil response, and the absence of reflexes. In most cases, this is pretty supportive, saying this person's dead. But there are also odd cases in which the patient is hypothermic that we may not see many of these things if we're not paying real close attention. So in and of themselves, these alone really shouldn't be, you shouldn't pick one of them and say, oh, well, they're unresponsive to all stimuli, they're dead. You need to use all of these, as well as looking at additional things such as dependent lividity, which is referred to as liver mortis, where the blood sinks to the dependent or the low parts of their body. And there's a picture coming up of that. In fact, I'll go there now. There's dependent lividity, liver mortis, in this gentleman's arm, where his blood has dropped and started to pool there. And you can also see where his body started to break down and blood is come out of his face. So that would be an interesting scene to walk into. Then there are the later signs, or the more concrete signs of death, such as decapitation. Like I said, you can't survive that. When your brain leaves your body, that's non-survivable. Transection of the body's cut in half through the core somewhere. Generally, that's not survivable, just simply for the fact you get too many large arteries. So if they've already died, then they're dead. They're decomposing. Their body's breaking down. They're charred or burned to death. Liver mortis, rigor mortis, those are additional signs that help support that. Additionally, you may be on a service that you can apply a cardiac monitor. If you can put a cardiac monitor on a patient and are working it correctly, and it's within your protocol to run it in all three leads, that this is a flat line, that's generally also a good supportive measure. However, that may not be the way your service is set up, so I'm not going to recommend that you do that, but paramedics in many cases will use that. We will throw the cardiac monitor on them, we'll flip it to lead 1, to lead 2, to lead 3, and then run a strip that shows that it is flatline, or what we call asystole. All right, so decisions to terminate resuscitative efforts can be made in consultation with a medical director or with a physician or online control. You got to follow your protocols. May require you to notify either the coroner or the medical examiner, and in cases where suspicious death was not due to natural causes, law enforcement. So a couple items on here. Number one, it is acceptable for AEMTs and EMTs alike in Iowa to terminate resuscitative efforts. If there's a protocol, if they get in contact with the hospital or medical control and explain the situation, the protocol allows it, they can then stop doing CPR and end their resuscitation there. In fact, it's being encouraged in more and more settings, because I mentioned previously that patients that are treated by paramedics for cardiac arrest, they're really not going to get much more, if anything more, in the emergency room once they get there. So there are services now that are saying if it's a cardiac arrest, we're going to work it on scene for 15 minutes, give it the full paramedic ALS treatment, and if we get nothing back, we're calling it, and we'll call the funeral home. So again, kind of a change of paradigm for us. And of course, we have to have protocols to support all this. You may be required to notify a coroner or a medical examiner. In the state of Iowa, you will notify the medical examiner. In the state of Nebraska, you notify the coroner. Iowa does not have a coroner system. Nebraska does not have a medical examiner system per se. A coroner is an official that's elected or appointed to investigate deaths. So they don't necessarily have to be suspicious, but that's their job. This can be, and in most cases, a coroner system is the sheriff, is the coroner. So a person with no medical education. A medical examiner, on the other hand, a county medical examiner is a physician. Preferably it is a physician who is a pathologist, but not always. And in the smaller counties, of course, pathologists, they don't have any. So the state medical examiner, I believe it's still Dr. Gooden, but is a board-certified pathologist, and they investigate deaths. And the medical examiner can appoint deputies. They can also appoint, and when I say deputies, deputy medical examiners, not deputy sheriffs. Well, in some cases, I guess it could be both. Or they can usually appoint other medical professionals, such as paramedics, to be examiner investigators. And I was able to participate in that a little bit when I was still working in the field as a medical examiner investigator for the county that I worked in. So that's who you have to contact. And then law enforcement almost always shows up with us anyway, but if they didn't, we make sure we get them involved. Okay, so you respond to the home of a 87-year-old woman who is down. Home, you find the two daughters. One daughter says, "Mom did not want resuscitation." The other says, you have to save her. What would you do? Well, I think the first thing you ask is, where's the DNR? Is there any documentation that backs this up that she doesn't want anything done? If there is documentation and it's appropriate, then you don't have to do anything. If they can't find it off the bat, then you have to get started. And then if necessary, get a hold of the ER and say, here's what we got. Can we terminate efforts? Or do you want us to transport in? So involve more people. So matters of civil law. When a patient or another person suffers damages as a result of an EMS provider's action, the injured party may have cause to sue that provider and seek monetary award and compensation for damages. This is the reality of it. We are in a suit-happy society, and that tends to be the way people think these days. So if you are sued by somebody, the person suing you is the plaintiff, and you are the defendant. So you are defending your honor, your reputation in court. In most cases, you also have an attorney to assist you. You would consult with an attorney prior, hopefully, to just showing up at court. Relevant information generally is pulled out during a phase called discovery, in which they're going to look for things like your run reports, look for other potential evidence that supports or incriminates you, and then they'll try to determine if there's any liability. If they see in favor of the plaintiff, they'll look to see if there's any liability and the damages that are due to the plaintiff. Sadly, this does happen from time to time, but in most cases that it happens, it is in a case of negligence. So again, talked about the plaintiff there and the defendants, and then usually it's argued in front of a jury. So again, negligence. Negligence is the most common time we see this come up, and there are 4 elements required to prove negligence: duty to act, breach of duty, damages, and then proximate cause or causation is what is often called. So what did each one of these things mean? We need to look a little closer at those, and hopefully you recall these from your EMT class. They really haven't changed, but duty to act is, was there a reason for you to be there? Okay, so were you contractually responsible for being there? Did you have to respond to calls that day? Were you on duty? If you are a volunteer, that becomes usually a little bit more cloudy because you're a volunteer, you're on call 24 hours a day. Whereas if you're a career, were you punched in or not? That makes it usually a little cleaner. Secondly, was there a breach of duty? Did something happen that was incorrect, whether it was an act of omission or commission? An act of omission means you left something out you should have done. An act of commission means you did something you shouldn't have done. So you did something either incorrectly or you shouldn't have performed a certain procedure. So the breach of duty usually falls into either malfeasant, misfeasant, or non-feasant. And you can look at those. Actually, we'll look at the next couple of slides that will explain those a little better. Then we're also going to have to see that there is actual damage. So did the patient actually suffer either mentally or physically as some sort of damage? And then the last bit of this, the proximate cause or causation, is actually being able to connect that damage to the duty to act and the breach of duty. So that's kind of the purse strings that cinch it all together and tie all 3 of those other components. It says, yep, absolutely. So there's our 3 categories of breach of duty. Malfeasance is performing an improper act. Misfeasance is an improper performance of a legitimate act. So you did what you were supposed to, you just did it wrong. Where malfeasance is you didn't even do the right thing. And then non-feasance is you didn't do it at all. So that's an act of omission is non-feasance. Commission is malfeasance and misfeasance. Now we may also look at in a civil case when we're talking about the concept of res ipsa loquitur, which is the burden of proof shifts to the defendant. So you can then you have to really things have to speak for itself, and it really is getting stuff that backs you up. Both sides really are trying to back up their own side of the thing. So in most cases, the burden of proof is on the plaintiff. They have to prove that it happened, but that plaintiff can invoke the res ipsa loquitur. All right, so to kind of wrap up that concept of negligence, remember that you're going to be judged on the standard of care. And the standard of care is really the reasonable person standard again, is if people were able, if other people were in the same situation, what would they do? That reasonable person standard might be like on Family Feud. Of 100 AEMTs polled, survey says, how many people would have said, oh no, I would have done it this way, or how many people would have done it exactly the same way that you did it. So that will be another concept or another topic that would be discussed in some sort of a case. So they're going to look at things such as how were you trained, what are the national standards, national guidelines, state and local protocols, and whatnot. All right, so a civil case, the defendant need not be found guilty beyond a reasonable doubt. In criminal cases, they generally are. We talked about that. So harm. They can be remunerated monetarily for physical or psychological or financial damages. So if because of what you did they incurred a lot of extra expense for their rehab or their hospital stay, even though they maybe didn't have a physical or a psychological permanent problem, it caused them a financial burden. So those sorts of things can be awarded. And they're going to look at that proximate cause, which is drawing that link of all of those things together, or a causation. So scope of practice, we've talked about that. Standard of care, we've also talked about that, and the reasonable person standard. So you guys should be able to answer all these questions on your own. Other civil claims. So we're going to start to talk about some other things that may happen. Breach of confidentiality or defamation, those things get big. If you start leaking information to the press or talking about it around town, and the other person finds out, that is their right to protect their privacy. You can defame their character, and that's an intentional false communication regarding a person's reputation. And in those cases, it's most likely going to be a case of either slander or libel. Slander is spoken and libel is written, so I like to think of it as well. Slander and spoken both start with an S, and libel and Bible both sound the same, and the Bible is written. So that's how I try to keep those two straight. So spoken is slander. Oh.